Thank you for joining us for the third in our series of webinars providing legal know-how and insight on the impact of COVID-19 on the construction industry. Our colleagues from our offices in Dubai and Dublin have run similar webinars specific to their jurisdiction. In this webinar, we will focus on the UK. I am Sheena Sood, Senior Partner of Beale Co, and I'm delivering this webinar with my partner Antony Smith, Chairman of Beale Co. So the agenda for our webinar is as follows. The first two webinars have covered in detail COVID-19 and the impact it is having on construction projects, and as well as the operation of construction contracts. As set out on the agenda, in this webinar, I'll be looking at the current position where we are now. Antony will then cover the medium term, getting back to work, and some of the issues to be considering. And we will then have a Q&A session discussing some of the longer term implications and challenges for the construction industry. And then finally, I'll wrap up with some closing remarks and direct you to some useful reference material. As far as questions are concerned, please feel free to post any questions that you might have, and we will respond to those questions following the webinar. So where are we currently? I'm going to divide this into the government response, the HSE response, and the industry response. And this will be a recap of the key documents, guidance documents, statements that have come out from these three sources that are relevant for construction. Firstly, the Coronavirus Act 2020. The Act was given royal assent on the 25th of March 2020, a day after the official start of the lockdown in the UK. The Act provides a variety of measures to allow government and public bodies to slow the spread of the virus and to ease the administrative burden on public bodies. The main measure, probably the only measure to note for the purposes of this webinar, is Section 52, Schedule 22, and that contains the government's power to issue directions relating to events, gatherings and premises. And we are taking that to include offices and construction sites. What it says is that if a threat to public health is declared by the government, they can close down premises. Non-compliance will be a criminal offence. Now, no such declaration has yet been issued by the government, and hopefully, if we do get the virus under control, that won't happen and the powers will never be utilised. But we think it worth noting that those draconian powers do exist currently in our law. In relation to grants, loans and schemes, you will have all read about the grants and the various support packages that are available to businesses through the crisis. So I don't intend to cover those in detail, save to note that there are a variety of different schemes available for SMEs, large businesses, the self-employed and sole traders. In addition, the government has announced plans to add new restructuring tools to the insolvency regime in this country, which is designed to stave off insolvencies. Certainly, our feeling is they need to get on with those measures because the depressing statistics that are coming out as to construction companies falling into liquidation is stark. It's probably too early for those stats to be COVID related, but it's a certainty that we'll see a sharp spike in those statistics. The best place to look for details of the support is on the government website. The Office of National Statistics, interestingly, reports that the majority of UK businesses in hospitality and entertainment, as we know, temporarily have closed between middle of April, start to middle of April. So 81% of accommodation and food businesses and 80% of arts and entertainment businesses have temporarily closed. That's a huge number. But by comparison, fewer than 1/4 of remaining businesses across other sectors have paused trading. All other businesses, or certainly that the majority of other businesses, have been able to continue trading in some way. The PPN notes, these are the procurement policy notes that have been issued by the government as an urgent response, relate to public sector works. There are 3 of them, and really it's only the one that I've listed on the slide that's of relevance, PPN 0220. And this covers the use of various measures by public sector clients to assist payment of their suppliers and ensure service continuity through the crisis. The key points to note are firstly that it requires an urgent review of contract portfolios by public sector clients, to consider suppliers that might be at risk, and to be actively contacting those suppliers to provide them with the assurance that they will be paid as normal, at least until the end of June. It states that measures should be put in place to ease cash flow, so forward ordering, advance payments, interim payments, payments on order are all set out as measures that can be taken. If a contract provides for payment on results, then the guide says that payment should be on the basis of previous invoices. An average over the last 3 months is suggested. And invoices should be paid immediately on receipt. So as I've said, that PPN is applicable for public sector projects, but there's no reason why the principles that are set out in that PPN shouldn't be adopted by the private sector. And it will be interesting to see whether or not that happens. In relation to construction sites, after an initial lack of clarity on announcing whether the lockdown applied to construction sites, could they or couldn't they stay open, it took intervention from the CIC and the Construction Leadership Council to step in order to get much needed clarity. And we had the government, or the Secretary of State for Business, issuing a letter to the construction sector on the 31st of March, clarifying that sites could remain open as long as the 2-metre social distancing rules were adhered to. I'll come on to discuss the sector-specific guidance that was issued this Monday on working safely on construction sites. Other matters of relevance for construction are that construction workers were added to the list of people that can get tested. And that happened on the 4th of May. So the list was updated, and one of the categories of workers that were included in the list was construction workers. And then on Monday, we had the PM's address to Parliament following his address to the nation on Sunday night. And we will have all heard him say that he now needs to stress that anyone who can't work from home, for instance, those in construction and manufacturing, should be actively encouraged to go to work. And he specifically mentioned construction workers. That was followed by government guidance that was issued on Monday for employers by type of work. And there were 8 workplace guidance documents issued for different work types, and 1 specifically for construction and working outdoors. That's available on the government website. The key points to note from it are that it requires employers to carry out risk assessments. It imposes a duty to consult their employees. And the emphasis is very much on employers and employees working together to resolve the issues. Risk assessments need to be shared with the workforce, and employers should consider publishing the risk assessment on their website, and that's expected for those employers with over 50 workers. It should also be displayed at workplaces. The rest of the guidance really sets out measures that ought to be taken to make the sites COVID safe, talking about the frequency of hand washing, etc., reducing the number of people that have contact with each other through fixed teams, and also obviously the 2 metre social distancing rules. Interestingly, what it doesn't mandate is the use of additional PPE on construction sites, and that's left up to employers to decide whether or not such additional PPE will be provided. And then finally, we have the Cabinet Office guidance on responsible contractual behaviour, and this relates to the performance and enforcement of contracts. What it promotes is reasonable, fair behaviours on construction contracts, designed to support the response to COVID-19, protect jobs and the economy. And it echoes some of the behaviours that are set out in the PPN that I've mentioned. It is a soft touch guidance document only, and it's really reflective of the fact that the government in this country can't interfere with commercial trading without Parliament say so. And that's unlike in other countries like the UAE, where governments can issue decrees. Why we think the Cabinet guidance is important, whilst only being guidance, is that it might lead to statutory intervention if the principles are ignored. And also adjudicators and other dispute resolvers may be mindful of that guidance when they reach their decisions on performance on construction contracts and how people conducted themselves. Moving on to the health and safety response, I'll deal with this slide first. Just a reminder firstly about the Health and Safety at Work Act, which is obviously enshrined in our legislative framework and in our everyday lives. It imposes wide duties on employers, as we know, to protect the health, safety and welfare of employees whilst at work. And there are equivalent duties on each of us towards each other. And I think it's important to remind ourselves of the duties that are set out in that Act, because they remain fundamental and the foundation for everything really, all actions that are taken in relation to COVID. The HSE has additionally stated that the RIDDOR reporting requirements, the reporting of injuries, diseases and dangerous occurrences regulations, is extended to deal with COVID. What it requires is if there is a COVID-related, if there is an unintended incident at work that has led to the possible or actual exposure of an employee to coronavirus, then that must be reported as a dangerous occurrence. Secondly, where an employee is diagnosed as having COVID and there's reasonable evidence that it was caused by exposure at work, then that must be reported as a disease. And if an employee dies as a result of occupational exposure to coronavirus, then that must be reported. So all employers need to be mindful of their obligations under the RIDDOR requirements. As I mentioned, access to testing is now in place for construction workers, and that might give rise to employees obviously testing positive and there being a question mark over whether they were exposed whilst at work. If you decide not to make a report for a relevant employee, I would suggest that you document your thought process. And also in asking questions of your employees in relation to their health, please be mindful of your GDPR obligations. In relation to enforcement, the HSE, the Health and Safety Executive, is the enforcing authority for the Public Health England guidelines and the government guidelines on controlling public health risks. So they are the relevant enforcing authority. What the HSE have said is that they will be using those guidelines to assess whether employees are meeting their obligations to take care of the health and safety of their employees. And the guidance issued on Monday itself states that the HSE or the local authority will identify those employers who are not taking action, and there will be a range of actions that the HSE can take to improve the control of workplace risks. And that might include the issue of improvement notices or other enforcement notices, or, and we would hope this is the case, advice being provided by the HSE to employers. The industry's response. This has really been led by the Construction Leadership Council, but other bodies like the CIC and the ACE have also provided useful guidance. The Construction Leadership Council has so far issued 3 versions of its site operating procedures, the latest on the 14th of April 2020. And broadly, the onus is on site operators to undertake risk assessments, taking into account the type of work, location of the workforce, supplies, and making decisions about whether sites can stay open. This is now likely to be updated following the government's specific guidance issued on Monday. What both the site operating procedures and the government guidance are aimed at is introducing consistent measures across construction sites. The CLC document is useful. It contains a hierarchy of controls needed to seek to maintain the 2-metre social distancing, but other control measures as well. It has come in for some criticism. Unite in particular have said that they are critical of some aspects of the construction leadership's document. Their view is that no site should be worked on unless it's safely able to maintain the 2-metre social distancing requirement at all times. And we know that that's in direct contradiction to the site operating rules and the government guidance, which does allow the 2-metre social distancing to be breached. On a positive note, examples of what construction companies are doing that are innovative. Interserve have been trialling a new social distancing warning technology called Site Zone Safety, which is a personal distancing system aimed at helping to enforce the 2-metre rule. And the idea is that it's worn on a hard hat or a belt, and it sets off an alarm if workers get too close. The Construction Leadership Council have also issued a contractual best practice guidance document, and Antony will come on to talk about that in a bit more detail. I'd note that the CLC have this week launched a survey which is seeking intelligence from the industry as to how contracts are being impacted by COVID-19. And I would urge everyone to respond with data so that that can inform the work of the CLC going forward. I just wanted to mention some of the issues that we are seeing over what we have seen over this period from the start of the lockdown, and the questions that have been asked of us. I mean, clearly there have been a lot of questions raised about the provision of notices under construction contracts and appointments, and that topic was covered in a lot of detail by my colleagues Will Buckby and Nadir Hassan in their webinar, and there is a link to that webinar on our website. I have included in this slide pack a useful table that they produced, which sets out the relevant clauses under various notice provisions, various notice provisions under various standard form contracts. And that's a useful guidance document that can be used. I'm now going to hand over to Antony, who will talk through some of the medium-term implications for construction.
Thanks, Sheena. That's a very helpful summary of the first 2 months of the virus. It is estimated that only about 1/3 of sites remained open during the early part of the virus. That figure probably went up to about 2/3 open by last week, And now, with the Prime Minister's statement on Sunday, we expect most sites in England will be open within the next 2 weeks. The advice that we gave in our first article on the virus on the 2nd of March was operate your contract properly and serve your notices. The helpful chart that Sheena just showed you at slide 6 shows that most of the major forms of contract require some form of notice. So what should you be doing now? Depending on when you served your notice, you should put in a quotation for your costs if you're entitled to money and an amendment to the contract programme. You should mark down the dates you put in those quotations and programmes and be ready to follow them up promptly with your employer. You should also consider, when going back to site, so the medium term, is it time for another notice? Over the last 2 months, you'll have been through a period of suspension, possibly caused by the government direction. However, you're now entering a remobilisation period, and a period when the first time ever you will be operating social distancing, something unknown 3 months ago. You must consider if that requires a second notice. In our view, it probably does. If that's right and you serve your second notice, then you're also going to have to submit your costs and the impact on programme in the appropriate timescale. There may be a need for a third notice. If, heaven forbid, the R number goes up on your site, or it's in a virus hotspot, it could be shut down again. And that will need a third notice. This may all seem very contractual to you, but if you don't operate the contract correctly, you will be on the back foot when the negotiations begin. Consultants, on returning to site, will have been less impacted by the last couple of months. They will have been working from home and hopefully will have continued producing their designs on time. However, the new working conditions on site may mean changes for the consultant as well. There may be value engineering that the client now requires because of the cost implications. There could be buildability issues. There could be program changes, which could all have an impact on design. Consultants will also need to think about their site staff and can they fulfill their monitoring and inspection roles once the new site working arrangements have been agreed. For example, some sites may go to a 24-hour 3-shift system, and the consultant will have to ensure that it's got sufficient staff to monitor the site on a 3-shift basis. Consultants' duties will also involve administering the contract, and where they've got that role, we anticipate a lot of work for them in carrying out that assessment and making sure that the contract has been administered properly. My next comments about knowing the project, knowing your client and the team, communication and behaviours apply equally to my disputes slide. What is important is that you make a commercial assessment once you're going back to site. Is the project viable after the virus? Will the client still be able to sell it? What's the financial position of your client? Will the contractor team survive? Who are the key subcontractors needed for completion? All those questions come into the mix, and you need to use information about the project to make decisions about your role going forward. You should look at each project individually and choose the right ones to take forward. You may not have a choice, but you can certainly make decisions about which projects you should now prioritise and allocate resource to. You may only find out which projects are viable from discussions with the client and other members of the project team, and by carrying out some of your own due diligence. Communication at this stage is key to finding out what is happening on site and what others may be doing. Your decision may well be influenced by the behaviours of others. If the client has always been late in paying you and regularly serves payless notices, are they going to change now when they're trying to recover from the virus? On the other hand, if it's a blue chip client for your business who have always been loyal to you, talk to them and find out what they need to make the project succeed. The Construction Leadership Council document last week called for fair and reasonable behaviour. That all depends if you're dealing with a fair and reasonable client, and you need to make that assessment about the client and the team. Moving on to disputes, the assessment you make about the client and the team and the viability of the project will all be relevant to your approach to disputes. It won't be long before you have to make decisions as to whether your claims are being properly dealt with by the client. If you have been talking to them throughout the project, throughout the virus, you'll have a good idea of their plans and can base your decision making on some evidence of the likely outcomes. There are many forms of dispute resolution in contracts, but most contracts have a basic tiered approach. The first step of the tiered approach is direct negotiation. Second step is mediation. And finally, if all else fails, then either court or arbitration. You always have the statutory right to adjudicate a construction dispute. Even if the contract doesn't provide for direct negotiation, you can still approach your counterparty for a commercial discussion at any stage, but always remember to use the without prejudice tag at the start of that conversation. It is absolutely vital to be prepared for direct negotiations. This is your best, cheapest, and quickest way to settle the claim. You should have done your homework on the client's financial position and where they stand in the industry. You should, as part of your preparation, prepare some scenarios, because you may be negotiating for the first time ever with somebody over Skype or Teams, which is very different from negotiating with somebody in a room or in a pub. Your scenarios need to set out the best and worst case for that client. You should also, in the negotiation, leave the door open by somehow referring to other decision makers. And you should also finally have your bottom line ready so that if there is a chance of a deal, you can actually take it. As I say, negotiating on Skype needs more preparation because it's all too easy for your counterparty to shut their laptop and walk away. If your direct negotiations fail, then maybe suggest you need some help from a mediator or a facilitator to keep the discussions going. Mediation avoids all the formality of court and can be done yourself if you want without lawyers. The mediator's job is simply to help you resolve your dispute, not to make any decision about who is right or who is wrong. And what the mediator does, they force you to look at your actual risks of taking the dispute forward. I cannot stress how important it is to do a merits assessment of your own case and then stress test it. There are some crucial decisions to be made going forward, and believing solely in your own case is always dangerous. If you decide to instruct a lawyer, get them to do a merits assessment early on as part of their advice. This means you can compare it to your own assessment. Also, if your lawyers are very bullish, telling you, yes, you're going to win, then ask them if they're prepared to share some of the risk with you in taking an adjudication or court proceedings. Already since the virus, we have seen a big uptick in adjudications, and we expect that to continue with people looking for quick results. If you are facing the long haul and a claim going through arbitration or the courts, and you don't like the look of the cost estimates you've had, then consider litigation funding as an option. Here, third-party funders are prepared to fund legal costs if there's a good case, but they will take a significant chunk of the money recovered. The funder will also do their own assessment of the risk, so again, it's another sense check, but be prepared to give up 30 or 35% of the monies recovered. These comments about disputes may all seem a bit negative in the light of the CLC statement encouraging everybody to act in a fair and reasonable manner in resolving disputes. Clearly, that is the hope, but we are just pointing out what you can do if people don't behave fairly and reasonably towards you. The RSES and the CIC have both introduced adjudication schemes for smaller value claims. I just wanted to point that out because if it's not a large claim, but it matters to your business, then it can be a useful way of getting a quick answer, enabling you to move on without spending too much on the process. For the final part of today's webinar, I hand you back to Sheena, who's going to raise some questions, enable us both to crystal ball gaze about the longer term.
Thank you, Antony. We thought we would do this section as a question and answer session where I ask Antony some questions listed on the slide to gain his personal insight into these points. So firstly, Antony, what do you see the impact being of COVID-19 on UK construction activity?
Thanks, Sheena. Obviously, we've talked all about the need for notices, the changes in working conditions that are going to happen on sites. But looking to the longer term, what I see are 5 changes. First of all, governments around the world are all promising huge spend on infrastructure projects. Even during the first part of the virus, the government has given the go-ahead to HS2. We see the Asian Development Bank promising large sums of money. So be ready for some very large infrastructure spending. I also see changes in design and modernisation of cities being necessary and design of that work being done. Cities are overcrowded. That's clearly why the virus is spreading so rapidly in cities. So we need urban designers to look again at how cities work, to introduce new cycle lanes, which has already been announced by the English government. So think about cities. Thirdly, we're all working at home. Without data centres, we could never have carried on in this way. And so we see a big development being data centres. Get into that sector if you can. Fourthly, renewables. I think less travel, the whole attitude of people, the lessons we've learned as a result of working from home will mean that people want to bring forward the renewables programme. And finally, offices. Clearly, you're not going to be engaged to develop, whether by design or building, new office developments. Landlords, for once, look as if they're going to take a bath. But what you may find is there's lots of jobs converting offices to residential and also converting offices into a different way of working that we've all learned from working from home. So I see those 5 areas, Sheena, as changes brought about as a result of the virus.
That's interesting. One of the points that I've been thinking about, given the focus on construction site activities, is whether we will see more modular construction, which was obviously extremely popular anyway and getting more and more popular. I wonder whether there will be an injection of activity on modular construction to keep construction away from construction sites, or construction workers away from construction sites. We'll have to see, but the focus on digital delivery and that kind of engineering, I think, is key. So next question, do you see changes in the way that we procure projects and in contracts happening?
I'm hopeful, Sheena, that if we go down this road of we're all in it together, we're all looking for solutions, we may see alliancing type contracts which depend upon collaboration between the whole of the project team being used more and more. At the moment, they're only being used by certain clients, such as Network Rail. But if the lessons learned from this experience do mean we're all in it together, I can see more alliancing type contracts. I also see that contract drafters will be looking to include COVID clauses. But the real problem there is who will take the risk. Maybe we'll see contractors who are actually asked to price for a pandemic at tender stage. But my hope is we'll see greater collaboration in contractual and procurement methods.
Yeah, I think it will be interesting to see which way it goes, or indeed if there is any change. Certainly this all lends itself, as you say, to more alliancing, more joint venturing, more collaboration. But if people if parties start to get very contractual and want to get protections in place in their contracts, then we can see the route that's taking. So it will be interesting to see the industry's response. Do you think COVID-19 will affect professional indemnity insurance? That's a question we're being asked a lot.
I think we all need to remember, even though it was only 2 months ago that we went into the lockdown, that there was already a very hard market for professional indemnity insurance. And that was caused partly by the cladding problems we all know about, but also because of some big claims and underwriters beginning to write for profit have pushed the cost of insurance up. In my view, there's no reason to think that hard market will change this year as a result of COVID-19. Do I think that COVID-19 itself will increase claims under professional indemnity policies, which again could push up the price of insurance? I don't think there will be many pure COVID-19 professional claims. I can think of a few examples, such as all of this working from home may make it much more difficult to peer review your own design team, for example, and the team may not be as joined up as if you're all in the same office together. So there's a possibility that lack of peer review could bring about a claim. I can see perhaps 1 or 2 will be sued because they've failed to administer a contract properly. And I can also see it being more difficult when it comes to monitoring sites, carrying out those duties with all the suspensions that will have gone on. But generally, I don't see professional indemnity claims increasing because of COVID-19. Finally, one change that I think will be an indirect result. Everybody tells us we are going into a very, very deep recession as a result of the virus. I think that's right. And it may mean that certain practices won't be able to afford their full insurance, so that they may be looking for lower limits, or they may be looking for larger excesses. And I think that could be the biggest impact of the virus on the affordability of insurance for different practices who are being hit by the recession.
Yes, I think that's right. I also foresee consultants on renewal facing discussions in relation to exclusion clauses that are now starting to appear in policies, and Antony. So, you know, we have seen wording from some insurance companies where they are now across their portfolio of insurance products seeking to insert exclusion clauses, which will be something that brokers need to be advising on at renewal. So finally, what impact do you foresee on dispute resolution in the future?
Oh, this is a difficult one, Sheena. When I'm in optimistic mode, what I hope is that the pronouncements of everybody from Prime Minister through to the Construction Leadership Council talking about we're all in it together, we've got to get out of it together, talking about fair and reasonable behaviours. I hope that the construction industry actually learns from this experience of working together, because quite frankly, in the past, the construction industry is a very adversarial industry, and it has always found the need for disputes. My hope is that there will be greater collaboration, greater working together, and finding resolution of disputes without the need for all the formalities that we've talked about earlier in terms of court and arbitration. So that's my hope. I don't see real changes in dispute resolution. What I hope is that there are changes in behaviours that mean that you don't need the same dispute resolution mechanisms that you use at the moment. That's my hope.
Yeah, and I think being realistic, because as you say, it's an inherently adversarial industry. The tools that are now available to get disputes resolved faster, quicker and cheaper are there, and I think parties need to be thinking very carefully about using those tools. Thank you, Antony. So just some closing remarks now. The Purchasing Managers Index, which is the index that charts construction activity, has seen a drop in activity to the lowest level it has ever been since the survey began in 1997. And we would have heard the Bank of England's forecast that the crisis is going to lead to the worst recession that we've had in more than 300 years. The drop in activity in construction stands out in comparison to other sectors, with house building and commercial activity being hit the hardest, civil engineering faring slightly better. The stringent conditions that businesses will need to have in place to return to work won't result in an immediate bounce back. There will be an impact on productivity. And in the face of those bleak predictions, we all of us need to recalibrate our businesses. We need a solid foundation in terms of financial management and people management. We need to be recalibrating to weather the storm, seizing the opportunities that crises always bring and adjusting and adapting to that, and at all times being mindful of our moral and legal duties that we owe to our staff and each other. There is no shortage of material out there on COVID-19, but I've added some useful links to this last slide. It just remains to be said to thank Antony for the session, which I hope that you have found useful. And in relation to questions, as I've said, please post those questions and we will follow up on those after the webinar. Thank you very much.